Good afternoon, everyone. Welcome to Venables Government Affairs Compliance Tune-Up webinar. I'm Ron Jacobs. With me today are Larry Norton and Alexander McGarris. Please note that we are recording the webinar so that it will be available for future reference. All of the phone lines are muted for the call and will not be open for questions, but we have the chat function on the webinar system so that if you have any questions, you can type in your questions and we'll try, if we have time at the end, to answer them. The recording and a copy of the slides will be available on our website after the program is over, along with some other materials that we hope you'll find helpful. Another thing that we wanted to remind you of is that we have a political law briefing blog where we try to keep everyone up to date on relevant events and things going on in the political compliance world. So we hope you'll take a look at that and tune into that on a regular basis. So today we've got a packed agenda for you, and as we get started in this election year and with a lot of what we expect to be both political and lobbying activities, we have three sort of broad categories to cover today. We want to talk about political activity and all the things that you, your organization, or your associations can do to be involved in the political process. We'll talk about lobbying at the federal and state level, some of the reporting obligations and compliance issues there. And then we'll finish up talking about gifts and entertainment and how those rules apply to your interactions with state and federal officials.
Well, as with most things in life, there are risks and rewards to engaging with public officials and candidates, and some of the obvious benefits are protecting your business and your brand, obtaining a more favorable regulatory climate, or in some cases business and tax incentives, or maybe a long view where you're simply building relationships that you anticipate you might need down the road. These days there really are few organizations or businesses that can afford to stay out of any sort of engagement with government officials or candidates. But on the other side of the ledger, there are risks. One that we're focusing on today are the laws that regulate this activity, which have been in tremendous flux and vary considerably from one jurisdiction to another. There are lots of eyes on your interactions with public officials, lots of public reporting that is available to your competitors, to regulators, to watchdog groups and the press. And the thing to be aware of as you engage in this area is that really one ill-considered gift or reimbursed campaign contribution can land you on the front page of the paper or subject you and your company to an investigation or potential liability. So our goal today in this presentation is to help you identify opportunities for more effective engagement with government officials while helping you to do that safely and navigate the risk.
So we'll start off today talking about political activities and some of the things you can and can't do and ways to navigate those minefields. We want to kind of think of it as a menu of political options. We don't want to be here to talk about all the things you can't do or the no's in the world, but really what are the different ways you can be involved through giving corporate contributions in states where they're permissible, using your PAC, hosting candidate events, being involved with Super PACs and other outside organizations to really give you a sense of all the different possibilities that are out there.
So contributions made from the corporate treasury are permitted in some states, the states marked in the chart in green, but in all but a few of the states shaded in green, there are some limits on those contributions. As you consider making corporate campaign contributions to candidates or parties in the states where that's permitted, be aware that in a few states there are requirements that the contributor, that is the donor, the company, file its own report with the Campaign Finance Authority. There are a couple of states that require that the board of directors either authorize the contribution or generally authorize the officer of the company to make contributions. And if you're lobbying in any state where you make a campaign contribution, there are a few jurisdictions where your lobbying reports will have to contain a list of the corporate contributions that are made a matter of public record. It's a whole different game at the federal level. There remains, notwithstanding some confusion in the press and over the Citizens United case, there remains a ban on corporations making contributions to candidates for Congress and for president, to the national political parties, or to other federal PACs. There are and we'll talk in a moment about, there are certain ways that corporations can be involved in federal elections through their own PACs and through candidate appearances before certain audiences, certain individuals in the company. Well, one basic principle that's important to remember with regard to the ban on federal corporate contributions is that you can't do indirectly what you are prohibited from doing directly. So, in other words, it is prohibited for you to speak with a couple of your employees or a number of employees and ask them to make contributions to a candidate and then reimburse them in some fashion through an increased bonus, raise, or other means. These are among the more serious kinds of violations in the eyes of regulators and have even been the subject of a number of high-profile criminal cases. Similarly, a corporation at the federal level can't facilitate fundraising. And what does that mean? That can take on a whole range of activities, but some of the more typical scenarios are an executive who asks her assistant to go around and collect personal campaign checks from other employees of the company and then uses the company's overnight delivery service to send those checks on to the campaign. So in most respects, again, subject to this couple of exceptions we'll get to in a moment, corporations can't help raise money for federal candidates or national political parties.
So now that we've given you the broad contours of the no's, particularly at the federal level, we'll talk about a few things that you can do within the confines of your corporation. And this applies in slightly different ways to both for-profits and non-profit corporations. So one of the things that corporations are allowed to do is to communicate with their restricted class. The restricted class will vary depending on the exact form of the corporation. For a for-profit company, it's going to be the executive personnel, sort of your salaried decision makers, as well as any shareholders and their families. On the nonprofit side, for membership organizations, it includes all of the organization's members as well as the organization's executives. If it's a trade association with corporate members, then it applies to the restricted class of the corporation, meaning the executive employees of the corporation, the shareholders, but only if that corporation has given the trade association prior approval on an annual basis to make those solicitations. Now, the communication with the restricted class includes requests to contribute to candidates, so that if, for example, a company could say to its executives, hey, we really think this particular candidate's important. He's been someone who's been supportive of our industry before. We hope you'll send a check to that candidate. As Larry said, though, you're not allowed to collect those checks, so there has to be a request to go directly to the candidate. You're allowed to use your corporate facilities if there's either reimbursement or advance payment, depending on the exact circumstances. So if you want to host a lunch with a candidate that includes people beyond your restricted class, it's possible to do that as long as the candidate or a PAC or some other permissible source pays the corporation in advance to use those facilities and for that catering. The other thing to keep in mind is that individuals who are associated with the corporation can do certain things on their own. And it's important to draw that distinction of your individual capacity from the corporate capacity. So a couple things to keep in mind when you're acting on your own. First of all, you want to make sure that you're using your own materials and you're not using corporate resources. So for example, we always recommend that you use a personal email account if you're a corporate executive who's engaged in campaign activity, that you don't use any corporate postage or corporate envelopes or letterhead when you're doing such solicitation. If you're going to be doing this work during office hours, then make sure that it's 1 hour a week or 4 hours a month. Now keep in mind, of course, that if you're an executive, your time is sort of, it's not a strict hourly kind of world. So if you're doing some time in the middle of the afternoon, then you kind of make up for that on the other end in the evening or in the morning. That's okay as well. As I mentioned, you want to make sure that you make the contributors send all their checks directly to the campaign. You don't want to collect those contributions using any corporate resources. That's very important. You also want to make sure that you're not using some of the company's resources to do this. Like, for example, you don't want to take a company vendor list to make the phone calls or to send out the emails. You want to use your own personal email addresses. Now, certainly, there's times when your personal contact file resides on a company computer. You want to be very careful there, but there's a difference between sort of your own contacts that you may maintain in the company versus the list of vendors, the list of franchisees, the list of company customers, those kind of things that are company property that you really have to be careful not to use those or it becomes an in-kind corporate contribution. One thing to keep in mind for lobbyists when it comes to soliciting others is in where the volunteer exemption doesn't necessarily shield them from all liabilities, but lobbyists, even if they're not using corporate resources, in some states have restrictions on the kind of fundraising they can do. For example, some states during the legislative session prohibit not only lobbyists from giving contributions, but also lobbyists from raising money, from acting as PAC treasurers, and other things like that. So at the state level, be very careful if you're a lobbyist that you're not violating those state rules that apply.
Well, I mentioned a moment ago that while corporations are generally prohibited from facilitating contributions to candidates and federal candidates, and may not make contributions either monetary or in kind, that there are a couple of ways corporations can still participate in connection with federal elections, and one of them is through what we generally refer to as candidate appearances. And that really means simply that you've invited a candidate for federal office to come in, that might be a current office holder or someone simply running for office, to come to the company and to meet with certain employees of the company in a conference room or in some other setting and talk about some of the issues regarding the campaign. There are two different sets of rules, two different sets of Federal Election Commission rules for when the candidate appears before the company. And the first set of rules applies to invitations to meet with your restricted class, which Ron defined earlier. And what that means is that the only people who are going to be in the room with the candidate are going to be your senior managers and your lawyers and accountants and so on. The only exceptions is that the Federal Election Commission says that you can have some support personnel there who are necessary to help you administer the event, and you can invite a featured guest. If someone is going to come in and speak at the event or something like that, they can be there too. But generally it's going to be your senior management. If you limit your audience to that group, there's an awful lot of flexibility in terms of what you can do. The candidate, as well as the company, can openly advocate for the candidate's election, or say things in opposition to the candidate's opponent. The candidate and the company are permitted to ask employees, encourage employees to make contributions either before the event, during the event, or after the event. And the checks can literally be handed by each person to the candidate or the representative of the candidate at the event. The only thing to be cautious about, and this runs through everything we're saying in regard to the federal rules, is that you should not handle the checks. So no company representative should go around and pick up checks and send them over to the candidate.
And that applies before or during the event, so that even if you're taking RSVPs to the event so that you know who's going to be there, how much food you need, collecting the RSVPs is okay, but actually collecting the contribution checks is not okay for the company to do. So a lot of times the invitation will instruct people to go online or send their checks to the candidate's fundraiser as opposed to someone within the company.
Well, the rules are a whole lot more restrictive if you want to invite the candidate to meet in the lunchroom or in a big conference room with all of your employees, meaning your rank and file, front level and frontline employees who are not in senior management positions and not members of recognized professions like lawyers, accountants, and so on. In that case, you are required to allow candidates for the same seat to have a similar opportunity to appear before your employees. That doesn't mean that you have to make any effort to invite them, but if they learn of the event and they ask to appear, you have no choice but to allow them. For the appearance before the restricted class, you needn't provide similar opportunities to other candidates. Again, you'll see other ways that there are restrictions here. The company is no company officer should advocate for the candidate in front of all of the employees, either at the event or prior to the event. There is a some room for the candidate or a representative of the candidate to ask for contributions, but all that may be done in that case is to leave envelopes. There's no collecting of the checks. So it's a much less used rule, but there's still some opportunity to have the candidate come in a pre-election capacity and address all of your employees. One of the important things to remember with regard to both this event and the restricted class event is that the company can pay for the meal. That's not considered a contribution or in-kind contribution to the candidate. So if you invite the candidate to come in and meet with your senior management, it can be a breakfast meeting or a lunch or what have you, and there's no issue, no contribution issue if you make that, if you pay for that meal on beverages out of the corporate account.
It's also, to keep in mind, it's possible to combine the two as long as they're physically distinct events. So you might have a breakfast with the restricted class and the candidate where it's a fundraiser event for the candidate, and then the candidate leaves that room and goes on a tour of the facility and meets with the other employees or addresses sort of all the employees. It just has to be that you've got to be careful what's said in which of the different settings.
So the other big sort of exception for involvement by corporations in federal election activity are corporate PACs. And I'm going to spend the next few slides talking about what they are and how they operate and how they're used. In broad terms, what a corporate PAC is a separate fund that where the funds come entirely from the voluntary contributions from individuals. That in almost all cases is the corporation's restricted class. The contributions are going to be made not based on anyone's personal political preferences, but on the company's interests and objectives. And it's the closest you can get as a corporation to making contributions in the company's name, because by law, the name of the corporate PAC the full name of the corporate PAC has to include the name of the connected corporation, the corporation that supports it. The rules permit the corporation itself to provide administrative support to the corporation to handle administrative and fundraising expenses, which we'll talk about a bit more in a second. But the real practical importance of that is that it ought to be the case that every dollar that you receive into the PAC is used to make contributions to candidates or political parties. And that, of course, is a very appealing selling point when you're attempting to interest your restricted class in making contributions to the PAC. So who funds a PAC? The question might also be worded here, who may you ask for contributions from for a federal PAC? But the law says that a corporate PAC or a trade association PAC may only solicit contributions from its restricted class. And in the case of trade associations, individual members who meet certain restrictions, or the restricted class of corporate members if there's been a prior permission. And here are as you see on the slide, these are the major groups covered by, who may be solicited for contributions. If your corporation has a connected PAC, the corporation or the PAC may make solicitations, so they could be in the name of either. And requests can be made of the same group, the members of the recognized profession, the salaried employees with policymaking experience, not just for the connected corporation, but also for its subsidiaries and its affiliated corporations. There's a limit on individual contributions to a corporate PAC. That limit is $5,000 per calendar year. If someone makes contributions to the federal PAC, those contributions have no impact on the separate limits that apply, $2,600 per candidate per primary, and same thing for the general election. So on the limits that apply to an individual's direct contributions to a candidate. We generally suggest that PACs discourage individual contributors from earmarking contributions for particular candidates, to understand that the goal of the PAC is really to further corporate interests and not personal interests. But in the event that you accepted a contribution that was earmarked in some fashion, that contribution would in fact count toward the individual's personal contribution limit. PACs are permitted to use payroll deduction as a means of raising funds. In fact, we encourage our clients to use payroll deduction. It, of course, automates the process. People are familiar with it. You're not required, as you would be if you received a check, to go back to the contributor each time you want to replenish the fund. It shifts the burden to the contributing employee to affirmatively opt out. And it's simply easier for people, most people, to make contributions in smaller amounts over a long period of time. And the rules for contributing to a corporate PAC are the same as contributing to a candidate for Congress or president, which is only U.S. citizens or green card holders can make contributions in federal or, for that matter, in state elections. Now, the PAC, of course, exists so that it can make contributions to office holders who are planning to run for election the next time around, or for candidates who don't yet hold office. And in that, for those contributions, the limit depends on how long the PAC has been in existence and how active the PAC has been. The limit that appears there on your slide pertains to PACs that have been around for at least 6 months and qualified for what's known as multi-candidate status. But for PACs that are just starting up, the limits are the same as the limits on individual contributions. Federal PACs may also make contributions to candidates for state office, for non-federal office, subject to state law. There are a handful of states that prohibit federal PACs from making contributions, but the bulk of them permit it, subject to some type of registration and or reporting. And in many cases, that's pretty minimal. It may simply mean that if you're going to contribute to a candidate for governor, that you have to file a copy of the same report that you file with the Federal Election Commission, or even just the pages that show the contribution to the candidate for governor. It's important for companies starting a PAC and for individuals who contribute to a PAC to understand that the contributions that individuals make are going to be publicly disclosed. If the contribution they make exceeds $200 for a calendar year in total. And of course, all the contributions the PAC makes are disclosed in filings with the Federal Election Commission. And all that information is available online and is searchable and is easily obtained. The requirement that PACs disclose the address of the contributor only means that you have to have either a home or a business address. And in most cases, our clients and those who contribute to the PACs are more comfortable using a business address, and the Federal Election Commission rules allow for that. Finally, we talked earlier about the ability of corporations to support the PAC in certain ways, and in ways that really allow the PAC to use every dollar raised to make contributions. And so a PAC, a corporation, meaning that the general treasury account, may be used to pay bank fees that are required in connection with the separate segregated PAC account, to pay for legal compliance, to pay the travel expenses for an individual to attend a candidate fundraiser and bring with him or her a PAC check. All those costs may be borne by the corporation, and none of those corporate expenses have to be disclosed on the Federal Election Commission report. The PAC may also do certain things to help raise money, the corporation rather, may do certain things to help raise money for its own corporate PAC, subject to certain conditions. The corporation can provide prizes and trinkets, can offer to provide a charitable match for an employee's contribution to the PAC. It's common when PACs sort of have a rollout that there might be an initial meeting or breakfast meeting where those who are running the PAC explain the advantages of the PAC and encourage contributions. If you had a breakfast for that sort of a rollout, that too could be paid for by the corporation. The one and a very important thing that a corporation may not do out of its treasury funds is make a contribution to the PAC. All the funds have to come from individuals.
So now that we've talked about what employees may do, what the company may do with its restricted class, and then how it can create a PAC, we want to talk about a few other options that are also available. And these are somewhat on the new side from the past few years, stemming out of the Citizens United decision creating independent expenditures committees or that allow independent expenditures by corporations, and some subsequent decisions that allow independent expenditure committees to be created. So I'm going to run through here. We'll talk about super PACs and then other trade association options that are available. So what is a super PAC? You hear a lot about them. At the end of the day, the key feature is that it's an organization that makes independent expenditures. Now, an independent expenditure is something that expressly advocates the election or defeat of a candidate. It's not a contribution directly to the candidate. So unlike the PACs that Larry talked about a minute ago, where the whole purpose is to pool employee resources and then make contributions to candidates by writing checks, a super PAC acts independently of the candidate and does not give money to the candidate. In terms of that independence, the key feature is that the super PAC may not coordinate with a candidate. So a candidate in the super PAC cannot discuss what the plans are. A candidate cannot say, boy, I really wish I had more direct mail on this particular topic, and the super PAC would say, great, let me do it. That's what's prohibited. The super PAC has to act on its own without taking direction from the candidate. Another feature of super PACs, I think this is somewhat of a misunderstood sometimes, is that contributions to a super PAC at the federal level in particular, and also in many states, are fully disclosed. It's another type of political committee, just like a regular PAC, that files with the Federal Election Commission so that all contributions into the super PAC are disclosed by name and address so that you know who's contributing to that super PAC. The other feature of a super PAC, unlike a regular PAC, is that there are no contribution limits on the amount that the PAC may receive, and it's allowed to accept corporate contributions. What we've seen over the past few years since the Citizens United decision is that, for the most part, with a few exceptions, publicly traded companies tend not to make the contributions directly. A lot of times it's individuals associated with the company, whether it be the CEO or other senior personnel, who fund the super PACs, but it is permissible for corporations to make contributions, and some privately held companies have been involved in the process, and those contributions then are fully disclosed.
It's important to remember that the same ban on foreign corporations that applies to foreign individuals that applies to contributions to corporate PACs would apply to the super PACs too. Exactly.
Now, the one area that's a little more controversial and that has generated some attention recently is the activities of nonprofits, such as 501c4s, which are social welfare organizations, and 501c6s, which are trade associations. These organizations, in the past, as corporations, were prohibited from making their own independent expenditures. They had to do all of their political activity through PACs. Now, however, they're allowed to engage directly in some of this activity. The key here is that neither a 501c4 nor a 501c6 can have as its primary purpose political activity. What exactly is the primary purpose is a matter of some debate. Generally speaking, there's a sense that as long as it's somewhere in the 30 to 40% range or less, it's a permissible level. But there's a great deal of debate about that. The reason that political activity by 501c4s and 501c6s is more controversial is that donors to C4s and C6s are not publicly disclosed. So if a company makes a contribution to its trade association or to a 501c4, and that 501c4 airs an independent expenditure attacking a candidate or supporting another candidate, the organization, the C4, will disclose how much it's spent on the ad, but it will not disclose the donors to the C4, except in fairly narrow circumstances where the donors sort of gave the money specifically for the purpose of funding the independent expenditure. So in general, there's relatively little disclosure there. The other thing that sometimes happens is that organizations will pay money into a 501c4 or a 501c6. Then the C4, the C6 will contribute to Super PAC. So the Super PAC lists its donors, and it will disclose that the 501c4 social welfare organization contributed to it, but then there's no further piercing the veil and going behind that. Now, for all we talk about this at the federal level, a number of states have gotten into this area And states have tried to sort of pierce the veil and take a broader view of when a C4 or a C6 makes independent expenditures. The state argues that it becomes a political committee and therefore has to disclose the donors. And that's been particularly the case in California. There's been some major litigation about when an organization has to disclose its donors. Washington State has been involved in litigation over not candidate independent expenditures, but from ballot measure committees, and when those organizations have to, when the C6s and C4s have to disclose their donors. So at the federal level, it's fairly safe to say that the C4 or the C6 does not disclose its donors, but at the state level, it's kind of a whole different picture.
Before you jump into the IRS rule, the only point that I sort of wanted to make is that this range of options for contributors is great in a lot of respects, because there are choices today, Super PACs and some of the politically active C4 groups that just didn't exist very much even just a few years ago. But it places more of a burden on the contributor to understand who in fact you're dealing with and how your contribution is going to be disclosed and when, and what restrictions they're under in terms of what they can accept.
Absolutely, and some of those perceptions can change over time when the state retroactively tries to impose disclosure requirements. A donor that thought its contribution was not going to be disclosed suddenly finds that it is disclosed after the fact, after it had been assured that it wasn't going to have to be disclosed. Now, as a result of this political activity by 501c4s and others, and the concern that perhaps there's more of it going on than should, or the concern that the donors are not being disclosed, the IRS has undertaken a rulemaking to try and figure out exactly how much is too much for a 501c4. And what's interesting, the IRS's proposed rulemaking focuses, it's almost as if there's a two-step. The current rulemaking focuses on what is political activity. It sets aside the question of how much political activity is okay. So it's a bit of a chicken and egg here, because as the IRS defines these things and then says how much is permissible, there's a feedback loop there, because the broad definitions that is proposed could require an organization to count more toward political activity than it would have counted otherwise. So even if 40% is the number, it's 40% of more activity being counted in that 40% than otherwise would have under these definitions. As I said, they're very broad. They capture things that in the past, even a 501c3, which can't be involved in political activities, could do. These new rules would suggest that the IRS would view it as political activity. For example, a nonpartisan voter registration effort, the IRS has suggested, would be political activity in there. And then the IRS has also said, well, okay, we're looking at C4s. What about 501c5s, which are unions, or 501c6s, the trade associations? So it very well could open the door to more restrictions, more limitations on what other organizations are doing. Now, as we've said, these are all sort of new options that weren't necessarily available to organizations in a variety of things, but with increased opportunities, there's also been an effort by sort of the good government groups, the reform groups, to try and limit what corporations can do. So a number of shareholder groups and other of the good government groups have tried to petition through the proxy process to get corporations to adopt certain political giving policies or political disclosure policies. Initially, these efforts really looked at things like, does the company disclose, are there processes in place? But in recent cycles of these proxy efforts, there's been less on just process and disclosure, more on, does the company do these things, should the company do these things? And there's a number of rating organizations that try to rate corporate transparency, and they give points for companies who don't engage in some of these political activities. So there does seem to be an attempt to try and chill some of the political activities. One of the things that's interesting is that the organization that ranks companies and has created a whole sort of checklist of how you get points. One of the great ways to get points is that you disclose all of your corporate contributions and any of your other political activity. Even though it's already disclosed elsewhere through most of the states, for example, they want you to put it on your corporate website. Now we've seen an effort where this organization has contacted some companies to confirm that the information on their websites is accurate, because they've said that what they're doing is creating a database of political activity. So you'll be able to use that database apparently to type in the company name and see where they gave all over, rather than going to the different state websites to try and find the information. So I think that's another interesting area where things are starting to change. And then finally, there's been a petition for several years to require the SEC, or to petition to ask the SEC to require disclosure by publicly traded companies of their political giving. That effort seems to have been set to the side in the most recent regulatory priorities document from the SEC, but it's certainly out there. There's been pressure for the SEC to act on that. It's something we want to watch very carefully.
So switching gears a bit, we plan to do a separate program this year on pay-to-play laws, but we wanted to mention them here briefly because these are laws at the state and local level that present a major risk area for companies that either are seeking business or do business with state or local governments or state or local government agencies, colleges, and universities. And in broad strokes, what these laws do are two things. One is they restrict or prohibit contributions by the entity, the bidding or contracting entity, but even more importantly, restrict or prohibit contributions by the contractor's officers, directors, in some cases they're PACs, and in most cases persons who are directly involved or supervise those who are directly involved in the negotiation of contracts with the state or local government. And the other thing these laws do, sometimes they do both, is require certain disclosure of political contributions by those same individuals. They're important to mention because the penalties for violating pay-to-play laws can mean voiding a bid, disqualifying a bid, or voiding a contract. So literally losing business, and in some cases being barred from obtaining business for some period of time afterwards. So very quickly, we have a couple of charts. We've indicated in shaded red that the states where there's a state law that prohibits a state pay-to-play law that either prohibits contributions, requires disclosure, or both, and then a sampling, but by no means an exhaustive list of major municipalities that have pay-to-play laws. And you'll notice that in some cases there is no state law, but there are municipalities with pay-to-play laws, and that the reverse is also true. So if your business model involves doing business with the government, that is contracts for goods and services in most cases, it's important to be aware of these laws and have a compliance program in place. And that there briefly is what's at stake.
We'll turn gears now and switch to talk about lobbying at the federal and state level. And we'll first talk about at the federal level what has to be disclosed when you're lobbying. And so there's a quarterly report that gets filed. The next one is actually due on the 21st of this month, so we're coming up on that very soon. And that report includes sort of three key categories. It includes the issues on which you lobbied along with the description, as well as the agencies lobbied, whether it be the House, the Senate, or any of the executive branch agencies. You have to disclose the total amount of expenses for lobbying, which includes both your internal expenses and also external expenses. We'll talk about that in a second. And then all of the individuals who act as a lobbyist. So in order to fill out that report and figure out your expenses, you have to know a few things and also have to figure out what exactly it means to be a lobbyist. So on the expense side, what are lobbying expenses? It includes the compensation for those that are engaged in lobbying activity, the pro rata portion of it, and that includes even non-lobbyists. So if you have someone who does policy work but doesn't do any actual lobbying contacts, you still have to track their time if that policy work goes into your lobbying activities. It includes a rent and overhead allocation for your government affairs staff. It includes other expenses like travel, hotel, or meals, or your direct expenses on lobbying. It also includes payments to outside consultants for your lobbying activity. So, for example, if you have both internal lobbyists, that would be in that first red bucket, but if you also have lobbying firms on retainer, that number also has to be calculated there in the amount as well. And then also any payments to trade associations and coalitions for lobbying activity also have to be included. So typically your associations will say to you, 25% of your dues goes toward lobbying or some other number, and then you include that in your lobbying expense bucket. Now, one of the keys there, phrases that we talked about there are lobbying activity. And so the question is, what is lobbying activity? Lobbying activity includes lobbying contacts, which we'll talk about in just a second, as well as all the planning, the research, and the coordination and preparation that goes into your lobbying activities. So in order for it to be lobbying activity, it has to be related to a lobbying contact. So at the federal level, a lobbying contact is an oral or written communication with a covered official, and we'll talk about covered officials in a minute, that relates to the formulation, adoption, or modification of legislation, the formulation, modification, or adoption of federal executive orders or policies of the U.S. government, communications regarding contracts and grants, and communications regarding nomination and confirmation of officials in the executive branch that are subject to Senate nomination or to court justices and things like that. So if you have a communication about one of those four broad categories and it's with a covered official, then it's a lobbying contact, and all of your planning, preparation, and research that goes into those contacts is lobbying activity. Now, what's a covered official? On the legislative branch side, covered legislative branch official is easy. It's everybody, from the scheduler all the way up to the senator or the member of Congress and everybody in between. They're covered officials. So if you have a conversation about one of those four items, like about legislation or a program or a policy or position in the U.S. government with anyone on the Hill, that's going to be a covered, that's going to be a lobbying contact. On the executive branch side, it's a little bit narrower. And kind of the shorthand is to think about political appointees as opposed to career staff. So it includes the president and the vice president, everyone in the executive office of the president. The executive office of the president includes not only the obvious areas like the White House counsel's office, but it also includes things like the Office of Management and Budget and the United States Trade Representative. So no matter with whom you're meeting at the USTR or OMB, that's going to be a covered a lobbying contact. It also includes everyone in the executive schedules levels 1 through 5. So that includes things like secretaries, deputy secretaries, on down the line, generally for the executive branch to someone like the general counsel. At the independent agencies, it's generally just the commissioners. It also includes all admirals and generals, and then Schedule C political appointees. So the next question is, who's a lobbyist? It's someone who makes more than one lobbying contact and spends more than 20% of their time on lobbying activities. So again, the lobbying activities includes lobbying contacts as well as the lobbying activities. So lobbying contacts, more than one lobbying contact, and more than 20% of your time during a 3-month period on lobbying activities. If you meet that definition of a lobbyist, then you're listed on the quarterly lobbying disclosure reports, and then you're also required to file a semi-annual contribution report. The semi-annual contribution report, called the LD-203, is due on January 30th, and that's filed by both the company or the registrant and also the individual lobbyists. That includes all of your federal campaign contributions above $200, any events to honor or recognize covered officials, meetings held by or in the name of covered officials, entities established or controlled by covered officials, and then presidential libraries and inaugural committees. There's a number of different nuances here, but in general, most organizations disclose federal campaign contributions, and then some organizations host things like Legislator of the Year awards, where they have to disclose those in terms of honoring or recognizing covered officials.
Very briefly on state lobbying, here you see the sort of major categories, and you'll notice something there that we haven't talked about before with regard to the federal lobbying disclosure, which is grassroots activity. Many states, more than half the states, regulate grassroots lobbying activity. And the thing to keep in mind when you're lobbying at the state or local level is there's tremendous variation in how lobbying is defined, what the registration triggers are, and what kind of reporting is required by the client or by the individual lobbyists. Again, a whole range of things to keep in mind. Some of the common things to remember are that there are states that require impose special gift rules like the federal government does on lobbyist employers and on government contractors. In many cases, someone from the company or the lobbyists are going to need to do training or do certain kinds of certifications. And I wanted to highlight the second bullet, Goodwill lobbying. There are about 7-8 states right now that regulate Goodwill, what they call Goodwill lobbying, which means that there isn't a particular matter or bill that you're attempting to influence, but your interaction is simply to cultivate a relationship with the covered official. In those states that have Goodwill lobbying laws, that's going to trigger registration and reporting. We've noticed in the last few months the emergence of big data in the world of campaign finance, particularly in New York, where a commission created by the governor has been using data analytics to try to establish patterns between political contributions and legislation or legislative objectives. And there's now a New York City ordinance that requires government officials to start scouring databases to see, to find evidence of individuals or companies that should be registered under the city's lobbying laws but have not. And we expect to see more of that big data role in the coming year.
And now we're going to switch gears, talk about gifts and entertainment. And first and foremost, we should define what we mean by gifts. And I think this is probably the most important slide in this presentation, in this section of this presentation, because the key to not violating these rules is being able to spot when you potentially have a gift issue. We have found that organizations can get into trouble typically when the activity that causes the issue is not flagged early enough as a compliance issue when it's being planned, and then later it arises. And so therefore, I think the major takeaway here is that the gift rules broadly apply to anything of value that's given to a public official or employee without receiving consideration from that official. And here we have depicted just some examples, some obvious ones, right? So meals and beverages and travel expenses, but also some not so obvious ones. So if you invite a government official to a charity event and don't charge them the fee that everyone else is paying to get into the event, that's considered a gift. Similarly with things that you send to their office. So if you are a magazine publisher and send a free subscription to a senator's office, that will be considered a gift. The good news is that while the term gift brings in pretty much everything under the sun that can be exchanged between human beings, the rules also include many exceptions which allow government officials to participate in everyday activities, such as taking advantage of government employee gift, gym membership discounts, for example, and also to engage with their constituents, or in the case of regulators, with the regulated community. So here we lay out the basic federal rules. And as you see, the scope of the restrictions depends on the branch of government or the type of employee, and whether or not the donor, as I mentioned earlier, is a lobbyist. And so with respect to the congressional rules, they apply to both members of Congress and their staff. And for individuals and entities that are registered as lobbyists or lobbyist employers under the Lobbying Disclosure Act, you cannot give any gift unless an exception applies. For non-lobbyists, you can give a gift valued up to $50 and $100 in the aggregate per year. The executive branch rules, they differ depending on the type of employee. So for career employees, those that are not appointed, you can give a gift up to $20, otherwise you'll need an exception. For political appointees, however, the rules are more restrictive. Under the Obama Ethics Pledge, which was an executive order issued by the President in 2009, political appointees really can't accept anything from either a lobbyist or an organization that retains or employs lobbyists. Just taking a step back, as you can see, the default rules are pretty restrictive, and that's why the exceptions are really important. And today we're really going to focus on the exceptions to the gift rules that permit federal employees and officials to interact with their constituents and the business community. And just to be clear, government employees typically can always attend meetings and events that they're invited to. The question is whether the sponsor of the event, the host, can cover the cost of that employee attending, either travel costs, the cost of food or beverages, or anything else that's being provided to those that attend the event. And so here we have the first exception that relates to widely attended events, such as conferences. And again, the rules here vary by type of employee. Members of Congress and their staff, they can attend an event if they're either speaking at it or otherwise determine that their participation is related to his or her official duties. To be considered widely attended, the sponsor typically should expect more than 25 non-Hill attendees, and it's got to be open to a wide range of individuals, not just, for example, the employees of a company. For political appointees, you can only accept free attendance to an event, travel, and food if the appointee is speaking at the event, so it's pretty restrictive. And the standard is lower for career employees, so long as the employee determines that the attendance is in the interest of the agency that he works for, he can attend. Under another exception, organizations can invite their member of Congress to visit their office or facility and cover some of the costs that are involved. So food and drinks, for example, can be offered if it's taken in a group setting. And the point of this requirement is to avoid situations where you have a lawmaker visiting the facility, he does the tour, and then goes up to the CEO's office and has an expensive meal with the CEO and the head lobbyist, right? An important caveat to this exception, though, is that the organization's lobbyists really can't be involved in planning or arranging the visit. The role has to be really limited to consultation in advance. If you as a government relations person that's trying to arrange a visit, wants to touch base with your lobbyist, get a sense of who might be an appropriate person to invite, you can consult the lobbyist at that point, but the lobbyist can't really help facilitate the visit. Under another exception, government employees can attend and participate in more casual reception-style networking events. This could even include receptions where just the employees or members of an organization are invited. The primary rule and requirement for Congress, members of Congress or their staff, is that the food and drinks served cannot be part of a sit-down meal. I don't know if the drafters thought nothing bad can happen if people were sitting down, or standing up, but that's the rule. And so the things offered have to be limited to hors d'oeuvres and breakfast foods, and nothing like pizza or real meals. For the executive branch, however, we have a dollar limit, which makes it really tough to cover if drinks are being served. So typically, you'll have executive branch employees pay their way, and this is fine. It's very common. And as the host, you just want to make sure you have a mechanism in place to handle requests to pay. For lobbyists that have personal friends or family in federal government, there is an exception for gifts that are based on personal friendship. And the key here is that the gift has to be really based on that friendship and not for another business purpose. And so it kind of goes without saying, but if you're giving a gift to a person that happens to work in government out of personal friendship, you cannot seek reimbursement from your employer or client. And the various ethics committees that enforce and interpret these rules have developed a common sense test for determining whether the gift is made out of a legitimate friendship, and that's whether there's a mutual exchange of gifts. If the gifts are always going one way from you to the government official, it's less likely to be a legitimate gift out of friendship. Same thing with the duration and formation of the friendship. If the relationship pre-existed, their role in the government, again, more likely to be a legitimate gift out of friendship. And if you're giving gifts to kind of every time every senator in a certain region, it's very unlikely that the gift that you're giving to a specific member of Congress is out of personal friendship. We don't have time to go through all the exceptions. However, just to know that there are many others. For example, you can give a member of Congress a plaque or other commemorative item. Similarly, you can send tangible products that are representative of the member's home state. I haven't been to Senator Leahy's office, but I always picture bottles of maple syrup all over the place. But keep in mind that every one of these exceptions, and this is not even all of them that we have listed here, have really specific requirements, and so you have to research them very carefully. And the bottom line is that you need to be able to identify where there's a potential gift issue and then bring it to the appropriate people to vet. I think 8 out of 10 times, in our experience, we're able to find a way to make it work in compliance with the rules, but oftentimes there do need to be tweaks. And so far we've covered just the federal rules. And as I'm sure by now you've picked up a trend, right? So just when you think you have it all figured out, we get to the state slide and complicate everything. But like the campaign finance and lobbying laws, each state has its own ethics rules with its own nuances. Generally speaking, however, you can expect kind of 5 things. So first, the definition of a gift will be broad, very broad. It will cover pretty much anything of value. And it will apply to all levels of government, so the officials and lower level employees. Oftentimes, the scope of the restrictions will differ between the legislative and executive branch, just like in the federal rules. And then in all cases, there will be exceptions, and none will be worded the same. So you really have to look up each state's rules and figure out how the exception works. And then finally, just like with the federal rules, there's oftentimes more restrictive requirements on lobbyists and/or entities that employ lobbyists. And also, this area of law is always in flux, and it changes rapidly. And just on Saturday, Government Call-Off signed an executive order creating new restrictions on gifts to executive branch employees in Virginia. There are entirely new rules. It bans gifts from lobbyists and from non-lobbyists up to $100. And there are a lot of exceptions that mirror the federal rules. And actually, we just posted a blog today about this if you're interested in kind of the more specifics.
I think just to make some concluding remarks and see if we can quickly answer a couple of your questions, there are some basic steps that we generally recommend our clients take to help manage the risks in this area. And importantly, if someone, you have a sort of rogue situation, and the regulators come in and they're looking to clamp down or impose a fine, you can point to things you're doing that were in good faith to protect against violations. And these are some of the basics, providing a simple and clear policies and procedures on volunteer political activity, on gifts, on pre-approval for interactions with government officials, and put those things in your code of conduct or code of ethics and distribute them. Provide regular training, whether it's by webinar or in person, where employees can ask questions. Make sure employees know who is responsible for answering questions, some of those types of things. I'd say sort of, I'll turn to Ron in a moment for his thoughts. I'd say that the guiding principle when we're providing advice to our clients is you can almost always do what you want to do or achieve a goal or objective and navigate the campaign finance and gift restrictions. But you need to be able to ask the question in advance and ensure that you've complied with all the requirements, or if you need to make some adjustment in your plans, you can make that adjustment before the event.
Exactly. I think that it's, as long as you ask first, there's usually a way to accomplish what you want to do. A couple other things to keep in mind. Don't forget to deal with your consultants. Make sure they're trained on these areas, your outside consultants. Make sure they understand what the rules are. Put in a process for pre-approval, because it's much easier to ask the question first than later. And assess your risks under the pay-to-play laws to make sure that you're not inadvertently tripping up yourself if you're someone who does business with the states. As we said, it's a heavy regulated area. There's a lot of traps for the unwary, but at the end of the day, a lot can be accomplished. The other thing to keep in mind, though, is that there may be a way to get there, but it also may be something that just doesn't look right. And so if this is something that's going to not be good to have on the front page of the Washington Post or your hometown newspaper, you might want to think about not doing it or doing it in a slightly different way. So with that, we'll turn to a few of the questions that you have real quick.
So someone asked who can make decisions on PAC contributions. There's no rule about who can do that. I think the important thing for a company with a PAC is to have a structure or a procedure that ensures employees who are contributing to the PAC that these are going to be evaluated in a nonpartisan way with business objectives in mind. And so, while not required, most of our clients have established a small board or committee that will evaluate requests and decide on PAC contributions.
And having that committee can also be beneficial in a couple other areas. Not only is it a good governance principle, but it also, that board can help to do fundraising and reach out to other employees. And it also, I think, in many times, gives a better sense that the PAC is for the company as opposed to just the government affairs department, and so you have an opportunity to sort of more broadly sell the organization.
So someone asked whether federal contractors can make contributions to federal PACs. I think the assumption based on Citizens United is that while Citizens United clearly said that corporations can contribute to PACs, there is a separate ban, prohibition in the federal rules on federal contractors, and that until there's a little more clarity from the courts, federal contractors are best advised, I think, to stay away from making contributions to super PACs or to any PAC.
We have another question as to whether PACs are incorporated. And I will say that PACs are one of the strangest creatures in corporate law. They're really a separate bank account. So if you're talking about a separate segregated fund of a corporation or a trade association, generally speaking, we don't incorporate those kind of PACs because it's just part of the corporation. They have their separate employer identification number for tax purposes, but usually they're not separately incorporated, although I have seen it happen before. If it's an independent PAC or a freestanding type of PAC, then yes, I usually suggest that that you incorporate to sort of circumscribe the liability and make it a little clearer as to what the entity is.
Last question was whether there are any states where replying to an RFP, a request for proposal, or a bid invitation requires registration as lobbying. I'm not aware of any. There are quite a number of states that regulate sales activity. Many of them call it procurement lobbying. In most cases, there are exceptions for formal responses to an RFP. What activity is typically covered by state lobbying laws are the meetings that you have to talk up a product, to encourage government officials to issue an RFP in the first place. Those kinds of things might require registration and reporting.
Or to develop specifications for the RFP, so that responding is not, but if you're trying to shape the RFP beforehand, then it often is considered to be lobbying. Well, thank you very much for your time today. We really appreciate it. We hope it was helpful. As you'll see on the screen there we have a number of publications on our political law practices webpage. We also have our political law briefing blog, as we mentioned. It contains more up-to-date information, and hopefully it's something that you can use to subscribe to, so you can get some updates when things change and when different areas, different changes to the law. If you have any questions, as we've said, feel free to visit our websites, or you can always email us and ask if there are any particular questions. So thank you very much.
Thank you.